Hi everyone, my name's Harvey. I'm probably not what you pictured when you heard fire safety talk. I'm 21. I've been in North East Fire Safety Solutions for 8 months now, so not a very long time. My background is in property and compliance management for alternative provision, if that means anything to anyone, which is basically specialist education. So that was within residential and educational settings. I've left the doofer on there, so cheers. So for the next 15 minutes or so, I just want to speak about something that I think affects every landlord in the room, and that's fire safety compliance within properties. I think fire safety compliance is quite neglected personally. It's usually left to a side, or maybe people think that it's handled by someone else within. So that bothered me. I went away, got my fire risk assessment qualification, a level 4 diploma, my NEBOSH general health and safety certificate. You go back there. Right. In England, there's over 22,000 fires every year and around about 350 deaths. The majority of these are in private rented homes. The fine for failing to comply with a fire safety law, well, there isn't one. There's no cap. It's unlimited. I'm not saying that just to scare you. I'm saying that because most of the landlords that I speak to genuinely don't know that. So they think that maybe a council notice, maybe a small penalty, but it really isn't. There are 4 main pieces of legislation that matter most. I'll give you basically the plain English of each one of those. The Fire Safety Order 2005 is a big one if your property has a shared hallway or a stairwell. So any sort of flat block or maybe terraced 2 flats. This law would apply to you and basically requires you to carry out a fire risk assessment and act on any recommendations that you are given. The building safety is newer and more relevant. Building safety is newer and more relevant if you own or manage anything over 7 meters tall. It creates new legal rules, the accountable person and the principal accountable person. They have serious duties attached, and if you've got a block, I would recommend that you read up on this. Next one is the Housing Act. This is the council's enforcement tool. They can walk into any rented property and assess the fire risk. Fire is a category 1 hazard, which is the main and worst category. An inspection that finds serious fire risk in an improvement notice or immediate probation of occupation. And the last one is the smoke regulations. This is basically the simplest one, but I would say it's the most commonly breached. You need a smoke alarm on every story, carbon monoxide alarm in any room with a gas boiler, log burner, and anything that burns fuel. Test it on the first day of every tenancy. If you breach that, it's a £5,000 fixed penalty notice. All of those laws reference the responsible person, so we'll talk about who that is. Every piece of fire legislation refers to that. So who is it? In most cases, if you're a landlord, it is you, not your letting agent, not your property manager, it's you. Unless you've formally transferred that responsibility in writing, the legal duty does sit with yourself. Something that I hear a lot is, my agent handles all of that. I'm not here to criticise letting agents, but most management contracts cover maintenance, not legal fire safety compliance. Right. Now we'll go on to who can actually carry out that fire risk assessment. The law uses the phrase competent person. For a simple single-story flat, any regular person who is pretty educated could carry that out. But for anything more complex, the expectation is a trained professional person. And if that goes to court, you need to prove competence, which an online template doesn't really do. So I'll talk to you now about what a fire risk assessment actually involves, because there is a big difference between a real one and the one that most landlords end up with. A lot of landlords think that a fire risk assessment is something that you can get online in about 20 minutes or so. Some companies will try and sell you one for about 30 quid, and I want to be clear on what that does get you and what it doesn't. A real fire risk assessment shows 5 legal stages. It identifies hazards, it identifies who's at risk, the evaluation and act on those risks, and it records everything in writing and reviews when things need changed. Each of those steps requires someone who actually knows what they're looking at and the moving parts within. The difference between a real assessment and a tick box exercise is the site visit, the photographs, and the property and people-specific findings. The red flags that I see constantly in assessments are ones that are created without a site visit, no photos, or using generic templates, which is just an address dropped into that template. Those documents will not protect you if a fire was to happen or if a council inspector comes knocking. If you've got a HMO, the bars are even higher. And I want to tell you something that recently happened that shows exactly why. So if you've got a shared house, even a small one, you're in a completely different legal category. The duties are more specific and the enforcement is more active. Grade D LD2 alarm systems, interlinked and heat detectors across the full property, not just individual battery alarms. A connected system where if one activates, they all sound. Fire doors, FD30 minimum on all living area rooms, so living rooms, kitchens, bedrooms are all required, with self-closing in intimate strips. And the gap under the door must be no more than 3 millimeters. If your tenants have wedged them open, which I see constantly, that's a compliance failure. Council inspections are routine for licensed HMOs. Missing equipment or a poor FRA can trigger a prohibition order. That means immediate eviction of tenants and even loss of rental income. I want to tell you something that happened on a job very recently because it illustrates why these things matter and why it's worth getting them right. I was carrying out an assessment on a HMO, a refurbished property that had just been done up and about to go live with their tenants. The managing agent had been through 400 renovations and were very experienced. When I flagged that the understair cupboard door needed to be fire rated and self-closing, she pushed back. She said it had never been raised before, not even by the fire brigade, which was probably mainly influenced by the cost of it. And I did understand the frustration. It's an easy thing to miss. But if that cupboard set directly on fire on the primary escape route, it's a major issue. So what happened next is actually the point of the story. Once she understood the reason, and you lose your escape route within minutes, she didn't push back, she got it fixed, and that's what the proper assessment does. It doesn't just tick the boxes, it explains why. So I'll show you what happens when these things aren't in place, which are real cases and have real consequences. So obviously there's one pretty close to home that happened in 2019. Mohammed Ayub in Sunderland had an unlicensed HMO on Tower Road. Fire broke out and there was no working alarms. There was no fire doors in place and he was fined £18,000 plus cost at Sunderland Magistrates Court. That's a relatively minor compared to what could happen. In Southwark in 2021, there was a £150,000 fine after a fatal fire in a converted HMO. There was no fire risk assessment, fire doors had removed, the landlord was required to know but didn't. In Manchester in 2022, there was a probation order, £20,000 in rent and repayment orders. That's basically a year's rent handed back to the tenants because the property wasn't compliant. These are a few myths that I hear regularly that landlords tell themselves. See if any of them sound familiar. There's one property, one tenancy. It still applies. The law doesn't care about the size of your portfolio. I actually had a landlord show me their gas safety certificate as proof of fire compliance last month, which is a completely different document and it's under a completely different law. Again, my agent handles all that. You need to check your agent's contract at your earliest convenience. Specifically look for the words that say responsible person. If they're not there, then that makes you the responsible person. And there's no once and done with fire risk assessments. They're a live document. There's so many moving parts within them. That could be structural, that could be people moving in and out, or it could be regulations changing. If you've had any of these happen, it needs reviewed as they need looked at basically every 12 months. I'll finish with something a bit more practical, which is something that you could literally go home and do tonight. There's 5 of these things. One is you can find your most recent fire risk assessment, check who did it, when, whether they visited the property, and if the action plan has names or dates. If it doesn't, then that document wouldn't protect you. Second one is again checking your letting agent's contract and just look for the words responsible person. If they're not there, you can make a call and basically decide who that is. Number 3 is just to test every alarm. You could do that in 20 minutes tomorrow morning and write down the date, and that log is evidence that may be required in the future. Number 4 is to check your fire doors, the self-closing features, the strips, the gap, and if tenants are wedging them open. Again, this is a licence condition. And the last one, number 5, is if there's anything from today that you're not sure about in relation to your own property, just don't guess, just find out. A quick conversation or a quick question is much better than finding out further down the line with a penalty fine or worse. That's all I've got for tonight. Thank you all for listening and giving me the time. If there's any questions, just give us a shout.
So you're saying that these need to be done on the annually or on the change of every tenancy? So if you had a tenant in
Both.
Year, so
Both, yeah. So if you had a tenant change, then you would need to get it done, and then the next 12 months later, even if nothing was to change, you would get another fire risk assessment done.
And you're saying it should always be done by a professional body as opposed to us doing a tick sheet?
Yeah, so what property are you talking about?
Just say three bed upstairs flat.
Yeah, so a single let flat.
Yeah.
Most people in this room, I would hope, would be able to do that themselves, just because it's not as thorough. You would just need your smoke alarms. You don't need any firefighting equipment legally. You don't need fire doors. If there was communal areas involved, then that's when it takes a step up. HMO, another step up. Commercial, massive step up. I hope does that make sense? Yeah. Yeah.
It's just happened to me. I had a 3-bedroom house,
Yep.
and when the tenants left and I did my checks, they destroyed the carbon monoxide and smoke alarm and moved the batteries out of it.
Right.
And I don't know when that was, because I do the checks.
Yeah. Yeah.
Who would have been liable if something had happened?
You.
So how do you protect it? I mean, that should never have opened it. I didn't
No.
visit it. I think kids want to batteries out. That's the only thing I can think of why somebody would do that, you know?
No.
But yeah, it was a brand new alarm when I went in.
Yeah.
I'd done the checks, and every check I did, I went and checked that it was working. And as I say, when it moved out here, it wasn't fixing at all.
Again, that just is the responsibility that comes with being the landlord and the responsible person. It's obviously, I think it's terrible, yeah. But, and to be fair, that is probably a rare occurrence in what you're saying, because you are doing, you do it. No, I've never heard of.
It's as rare as all that, if I'm honest.
Could you
But
protect
can I
yourself?
just pick up on that? Have you got an inventory on the tenancy?
Well, it says that the smoke alarm was checked and what date it is.
As long as you're logging those checks as well.
When the tenant moved in, you have a claim against them when they move out.
Yeah.
You're not returning the property in the same condition. If you end up in court because of it, then my gut feeling would be that you then issue counter proceedings against the tenant for putting you in that position.
Any more questions?
One more.
Regarding smoke alarms.
Yep.
I've asked the question to the council. I've asked the guy from the fire officer when he's come round. And I get different answers. In HMO on 3 floors,
Yep.
when you do your fire risk assessment, do you have to check every smoke alarm or just a smoke alarm on each floor?
I would check every smoke alarm. I think each assessor is different.
What does the law want you to do?
The law is at the time just every smoke alarm to be working, and the system, because it would be an interlinked system in a 3-story HMO. Which council is it?
Newcastle.
Newcastle. So each council's got different legislation again. So Newcastle could be different to Cleveland, could be different to Durham. But usually in the fire risk assessment, as long as they all sound at the same time in each room, then that would be considered compliant.
I think what I would add to that, Andrew, is you have an obligation to make sure that every smoke alarm is working in the property. If you don't check them all, you can't be sure.
Yeah.
As a landlord, not as a management agency. Do you know this, Bruce, right? If I've got a property in London, right, how do you expect me to go back and forth? 'Cause the management agency said that.
Well, in that
That's where.
scenario, you probably need to have a written agreement with the letting agent that they are going to pick that up on your behalf. Otherwise, at the end of the day, as Harvey said at the outset, I'm sorry, but like all landlord legislation, when the wheel comes off, it's you that's ending up in court, not your agent. And that's why I bang on about making sure your agent is doing what they should be doing and in the way that they should be doing it.
The onus is on all the landlords at the minute.
The onus is on the landlord to make sure that...
Something else I would suggest that you could do in your situation, you could assign some pretty basic fire safety training to a tenant and take that as their responsibility. So they could be doing, send a fire logbook down, and they could test fire equipment and fire alarms monthly, and that could be recorded. I know you can't rely on tenants too much, but if there was someone you trusted down there, even put them through training, and
Your travel down is tax deductible, of course.